This video examines Cross-Architecture LLM Ensembles, feature-based re-ranking, and retrieval-augmented prompting for legal information processing by Amal Saad Al-Shihari, Nelly Bin Como, and Amir Atapor Abargui. The purpose of this video is academic research and educational study. So welcome to today's lecture. All right, let's take a quick look at the syllabus on the board for today's explainer. We'll start with the title and research question, then define the specific NLP challenges in the legal domain. From there, we're diving into retrieving precedents, predicting judgments, and unpacking these cross-architecture LLM ensembles. Finally, we'll wrap up with academic conclusions and your key takeaways. Okay, moving right into part 1, title and research question. To kick things off, let's sketch out the fundamental bottleneck we're dealing with here on our flowchart. Look, the problem is glaringly obvious to anyone in the field, right? Legal language is just incredibly dense. A tiny, seemingly insignificant linguistic tweak can completely flip the legal meaning of a text. Plus, the evidence you need is often scattered across massive documents wrapped in highly specialized jargon. So this brings us directly to the author's core research question. How on earth can we structure open-weight AI models to reliably process all this complex information without relying on super expensive human supervision? To figure this out, they tackled the COLIEE 2026 benchmark, putting their methods to the test across a really rigorous 5-task suite ranging from case retrieval to statutory entailment. Which brings us to part 2, defining legal NLP challenges. Before we get too deep, we need to define a concept the authors lean on heavily: cross-architecture ensembling. Think of it like a law school study group. You've got one student who is absolutely brilliant at spotting double negations, right? But maybe they're terrible at structural rules. Another student has a photographic memory for structure but misses the nuance. Alone, they might bomb the exam. But if they pool their knowledge and vote on the answers, they ace it. In formal terms, this is when we combine AI models built with fundamentally different structural designs, like dense transformers and mixture of experts. They vote on the solution, ensuring that one model's specific blind spot is totally covered by another model's strength. All right, part 3, retrieving legal precedents. Let's actually trace the logic step by step for task 3, which focuses on Japanese statutory law. Now, Japanese text doesn't use spaces between words. So if you just apply a standard morphological analyzer, you run a huge risk of missegmenting specialized legal terms. The authors had a brilliant workaround for this. They bypassed the issue entirely by splitting the Japanese characters into overlapping pairs, what we call character bigrams. Then they cross-referenced those using a classic BM25 search. So a complex term like guardianship doesn't get accidentally chopped in half. It gets matched pair by pair, ensuring the exact right statutes are pulled even when the surface text is really tricky. Now, looking at task 1, which deals with Canadian case law, the approach is different, but honestly just as fascinating. We are talking about massive documents here. The median length is over 4,500 tokens. That completely blows past the context windows of many standard encoder models. So what did they do? The authors extracted 34 distinct features: structural, authority-based, and temporal variables. Then they fed those into a traditional machine learning model, a light GBM tree-based ranker. And here is the crazy part. For incredibly long texts where typical LLM truncation would discard vital analysis, this classical learning-to-rank system actually beat the zero-shot large language models. Pretty amazing, right? Moving on to part 4, predicting legal judgments. Okay, you have to see this massive performance shift that happened in task 2. Initially, the team used a single selection prompt, and they got an F1 accuracy score of 0.343. Kind of underwhelming, right? Well, it turns out the development set tricked them. In the dev set, 80% of the cases had exactly one correct entailing paragraph. But when they got to the actual test set, 95% of the cases had more than one. By simply dropping that rigid single selection assumption and tweaking the prompt to allow multi-selection, their post-competition F1 score skyrocketed to 0.555. That score would have easily taken first place. It is a textbook lesson in why you always have to watch out for development set distribution shifts. Next up, part 5, Cross-Architecture LLM Ensembles. Take a look at this table outlining the 9 experts used in their meta ensemble. The architectural diversity here is just wild. They didn't stick to one model family. They combined DeepSeek, Llama, and Quen. And they didn't just use one architecture either. They mixed dense transformers with these massive mixture of experts models. Look at the scale. We're talking about a parameter range spanning from a 70 billion parameter dense llama all the way up to a staggering 671 billion parameter DeepSeek R1. Plus, they mixed up the prompt instructions, using standard legal reasoning, strict chain of thought, and the classic law school IREC method. You know, issue, rule, application, conclusion. So, what happens when you combine all these diverse models into a hierarchical voting system? Well, the DU1 Meta Ensemble absolutely crushed the benchmark. It scored an unbelievable 96.3% accuracy. It correctly predicted 79 out of 82 complex legal queries and effortlessly took first place out of 33 submissions. But why exactly did it work so well? Well, the authors did this incredible error analysis on over 4,800 reasoning traces, and it comes down to complementary error profiles. For example, Quen missed critical legal negations about 56% of the time. But guess what? DeepSeek was right there to catch those negations. On the flip side, DeepSeek would occasionally hallucinate external legal knowledge, about 19% of the time. When that happened, the rest of the ensemble just outvoted it. Because the models were so fundamentally different, no single type of error could ever gather a majority vote. It's brilliant.
And finally, Part 6, Academic Conclusions and Takeaways.
Let's step back to the board and reconstruct the whole chain of reasoning here, because the authors absolutely proved their thesis. They started with a clear problem: processing dense legal text. They built a methodology that layered cross-architecture ensembles with feature-based re-ranking. The evidence, those top-tier benchmark scores we just looked at, totally validated the method. And then their analysis of error complementarity proved exactly why it worked. The final undeniable conclusion: solving advanced legal NLP requires diverse inductive biases working together. No single architecture is going to win everywhere. The main contribution here is genuinely massive for the field. They proved that open-weight models, meaning freely accessible, non-proprietary AI, can conquer the most complex legal reasoning benchmarks in the world if they are properly assembled and augmented. They basically handed us a unified blueprint for combining classical re-ranking on long texts with cutting-edge LLM prompting techniques. Now, of course, no study is perfect, and limitations definitely remain. The ensemble still trips up on really subtle quantifier distinctions. Like, it might miss the legal difference between the words all and any in a statute. It also struggles when conditional exception clauses interact in super complicated ways. And honestly, the persistent threat of truncation limits on those ultra-long case files, plus the ever-present danger of distribution shifts, are still big hurdles for everyone in this space. So where do we go from here? For future research, scholars really need to pick up exactly where this paper left off. We've got to investigate how to improve negation detection directly inside mixture of experts models, so we aren't completely reliant on ensembling. We also need a strong push for better calibration across diverse data splits, and we definitely need to expand those context windows so we don't have to lean so heavily on classical re-rankers. Okay, get your pens ready because you'll want these 3 key takeaways in your notes. Number 1, classical feature-based retrieval still absolutely dominates when you're dealing with incredibly long legal documents. Number 2, when you're building AI systems for complex reasoning, cross-architecture model diversity consistently beats just adding more pipeline complexity. And number 3, you have to rigorously test your strict prompt assumptions. Simply allowing multi-selection can often save you from catastrophic distribution shifts. Which leaves us with one final thought to ponder on the chalkboard. If these open-weight AI ensembles can already decode and entail complex statutes with 96.3% accuracy, navigating exceptions and double negations better than a lot of law students, how long until systems exactly like this become the standard, indispensable clerks of our actual judicial system? Think about that.